Shannon Stevens has sued her former employer, claiming she was fired because she is a woman.
Your Honor, permission to play excerpt number 25 from Mr. Roberts' deposition, lines 5 through 10.
Any objection?
No, Your Honor.
So John Patterson told you you had to reduce headcount in your group by 10% in a conversation that you and he had in January.
Yes.
Mr. Roberts, you're aware that Ms. Stevens was fired in February, right?
Well, yes. But when I said that in my deposition, I was just guessing. I wasn't really sure when John and I had had that conversation.
Mr. Roberts, were you given a copy of your deposition shortly after it was taken?
Yes.
And was that copy a word-for-word transcription of every question you were asked and every answer that you gave during your deposition?
Yes, but...
And weren't you given plenty of time to make any corrections that you deemed necessary in order to render that testimony accurate?
Yes,
And you, in fact, made some changes to some of your other answers, didn't you?
Yes, I did.
But you didn't change a word of that answer, did you?
No.
Let's take a look at what Pete did wrong and how his mistakes and the company's misfortunes could have been avoided if he had followed just a few simple rules for testifying at a deposition. Rule number 1, always tell the truth.
The courts of Canada and the courts of the United States have much in common due to their shared origins in the courts of England. That said, there are some differences. A few are cosmetic and others are more substantive. For example, in many hearings, both the judges and the lawyers will wear gowns, and decorum requires that the lawyer remain at the counsel table when speaking or examining a witness. The sort of pacing around that you saw in the opening segment would not occur in a Canadian courtroom absent permission from the judge. More substantive differences exist in the way in which witnesses can be impeached at a Canadian trial. First of all, out-of-court examinations are not videotaped unless the parties agree or the court orders otherwise. Accordingly, in the vast majority of cases, the lawyer will not be able to play back videotaped testimony in order to impeach a witness. However, in Canada, lawyers are allowed to read back a witness's prior testimony from a written transcript. This is sometimes more problematic because that written transcript will not necessarily capture the full context of the question or the answer. Even though the process is different, the result is the same. You can be impeached by careless testimony that you gave in your cross-examination or in your discovery. As you just learned, the most important rule when you are testifying in a discovery or cross-examination is to always tell the truth. Of course, the requirement to tell the truth whenever you're testifying under oath, and the consequences should you fail to do so, is the same in Canada as it is in the United States. Canadian judges and juries are just as unforgiving of any witness who lies in their testimony as are judges and juries in the United States. You never want to put your company or yourself in that position.
Rule number 2, don't volunteer.
So what happened next?
Well, one day John Patterson came to me and said, we need to reduce the company's headcount, and you have got to cut your group by 10%.
Did he?
Yeah, he did. And so I took a look at each of the 10 managers in the group, who was handling which accounts, who was bringing in what revenue. That's how I made my decision that Shannon Stevens was the one who we had to let go.
When did that conversation occur?
You know, it's been a few years now, and I don't recall the date.
Mr. Roberts, is it your testimony that you can't remember when your boss came to you and told you you had to fire one of only 10 people you supervised?
Look, I'm 90% sure that John and I spoke in my office at some point in January, so I'm going to say January. I'm not saying that at all, and I remember the conversation clearly. I'm just not sure of the exact date. Having had a chance to think about it, I believe John and I had that conversation at some point in January.
Your job in your deposition is to take your time and to listen very carefully to each question and to answer only the question that you are asked. Let's see how a more careful and thoughtful witness would have handled the questions Pete Roberts was asked at his deposition.
Mr. Morgan, what is your position at Patterson, Baird & Company?
Vice President, Account Management.
What are your primary responsibilities?
I supervise the firm's account managers.
Was Shannon Stevens one of the account managers you supervised?
Yes.
Is Ms. Stevens still employed by Patterson Baird?
No.
Why not?
She was let go.
Dan Morgan is a careful and thoughtful witness. He's listening carefully to each question, and he's answering only that question. He's not having a conversation with the other side's lawyer, and he's not volunteering information. As a result, Dan is calm and in control of his deposition.
The advice that you just heard, that you should not volunteer information or use colorful language, hyperbole, or absolutes when you are testifying, is equally applicable to discoveries and cross-examinations as it is to depositions in the United States. In fact, you can think of a deposition as combining into one what are two separate proceedings in Canada, the examination for discovery and an out-of-court cross-examination.
Rule number 3, don't speculate.
We come now to one of the main differences between an examination for discovery and a deposition. In most cases in Canada, when you sit for an examination for discovery, you will be sitting as a representative of your company. Therefore, in addition to the events and facts of which you have personal knowledge, you will be expected to testify about the events and facts that your company has knowledge of, even if you were not personally involved with them. Your lawyer will know in advance what topics the other side's lawyer may ask you about, and your lawyer will work with you to make sure you are fully prepared to provide answers that respond to those topics when you sit for your examination for discovery. Even though you may be testifying as a representative of your company, that does not mean that you should speculate or guess about any events or facts of which you have no personal knowledge. In fact, it may be even more dangerous to speculate during a discovery because your speculative answers, which, as we saw in the last segment, may very well be wrong, can be used by the other side's lawyer to bind not only you, but your company to those questions.
Rule number 4, read the documents.
Witnesses often fail to read carefully documents they are shown before they begin answering questions.
Let's see how a careful witness handles some questions about documents in his deposition.
Okay, Mr. Morgan, according to plaintiff's exhibit number 45, which you just identified as a Patterson-Baird client list, your company added 14 new clients between the period of July 1 and September 30, correct?
What page are you referring to?
Page 9.
This document states on page 9 that Patterson-Baird added 12 new clients between July 1 and September 30.
Rule number 5, listen to your lawyer.
One of the other major differences between the practice in Canada and the practice in the United States concerns objections. Now, thankfully, the rules in Canada make it easier for the witnesses on the examinations for discovery and cross-examinations. When your lawyer objects to a question, you will not need to respond to that question. This is the opposite of how it works in depositions in the United States, where, as we saw in the last segment, Dan Morgan was required to answer every question he was asked, even if his lawyer objected. In discoveries and cross-examinations, you will not be required to answer any question that your lawyer objects to, and you should heed your lawyer's objections. Because you are not required to answer any questions that your lawyer objects to, objections tend to occur less frequently in discoveries and cross-examinations than what we saw in that last segment. However, your lawyer will likely object to some questions during your examination, so it's important for you to be familiar with the rules. Your lawyer will take the lead with respect to any objections or issues of privilege, and it's very important that you do not answer any questions that your lawyer objects to, even if you know the answers, unless your lawyer specifically instructs you to answer the question despite his or her objection. By remembering and applying these 5 simple rules to your discovery or cross-examination, you should avoid making the mistakes that many witnesses make when giving testimony.